Thank you. This hearing is in the matter of case number CFI 041-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by MB Kemp, LLP. Lead counsel is Mr. Brian Kotick. The first defendant is represented by Tamimi and Company. Lead counsel is Mr. Bobby Friedman. The second, third, and fourth defendants are represented by Hadif and Partners. Lead counsel is Mr. Adrian Chadwick.
Very good. All right. This is a pre-trial review, but with one or two additional add-ons. Do you want to open the matter, Mr. Friedman?
Yes, my lord. Can I start by checking my lord has my skeleton argument that was sent yesterday?
No, I don't think I do. Yes, I do. Sorry. Yes, beg your pardon. Yes, I got first defendant skeleton argument, but nothing else.
Yes. So, my lord, obviously it's mellowed from Mr. Kotick's application for a stay. So I'm happy to address you on the position, or whether Mr. Kotick wants to make his application. I'm in your lordship's hands.
Yes, all right. Can I just ask Mr. Chadwick what he is hoping to achieve by being here, so I can see where we're going?
We have our application for under Part 12, but that's not to be determined today.
No. We
are also looking with interest about the application for a stay, and I've got some views on that which may be helpful or not to your lordship. Otherwise, we're really listening in on what's going to be happening about the stay application.
Yes. Well, I think I can say, because I don't think it. I mean, it's blindingly obvious that you can't participate in a trial taking place in September, Mr. Chadwick. So I don't need to hear you on that subject. And indeed, your application has to be dealt with first in any event, with regard to service and jurisdiction and so on and so forth. So in one sense, I don't think I need to hear from you at all at this stage, and you can remain an interested spectator.
I was curious to know if you wanted to make order for directions with respect to our stay application, but I don't think our own view is that's not needed. We have a timetable under the rules for when they need to respond. Both sides need to respond, and all that will need to be done in due course to fix a date for that hearing in consultation with council's diaries. So I don't think actually we need to address you on those points. I would like to make a couple of comments on their stay application in due course, but I'm in your lordship's hands.
Yes. All right. Well, unless there's disagreement about the ordinary timescale, we can assume that the ordinary timescale will apply in relation to your application, and a hearing date will have to be fixed for that in due course if there's no agreement about it. As to whether I need to hear you on the stay application, well, we'll wait and see what other parties have to say. In which case, really, it's for the claimant, I think, first to make its application for a stay, and then we'll deal with anything that may follow from that.
Thank you, my lord. This stay application was filed on the 17th of August, 2023, under the court's case management powers and RDC Rule 4.2, that the court may stay the proceedings until a certain date or a certain event has occurred, and also to adjourn the hearing. The object of the stay application is to vacate the trial dates and to stay the proceedings until service on D2 to D4 has been properly effected in accordance with the PRC and the UAE Treaty, but also in light of the new Part 2012 application that's been filed by D2 to D4, it also justifies a vacation of the trial dates and a stay of the proceedings until that has been determined. So there's actually two dates or events that are at play here for the purposes of the stay. The standard for granting a stay of these proceedings is whether it's just inconvenient to stay the proceedings under the court's case management powers. And in assessing the interest of justice and the convenience, the court should also take into account to prevent any abusive process, i.e. whether the application is vexatious or otherwise an abusive process in this case, but also to address whether it would prevent any undue prejudice to the opposing party, in this case, the first defendant. And also the second to fourth defendants. In the skeleton arguments filed yesterday by the first defendant has put forward a different standard for granting a stay application, and they have cited two cases specifically. The first case being Investment Group Private Limited versus the Standard Chartered Bank, in which the first defendant has tried to extract a new standard that a stay application can only be granted in rare and compelling circumstances. That case is far different than the case at hand, since that case dealt with parallel proceedings being brought before the DIFC court and the courts in Sharjah, and the court had to determine whether it was just and convenient in those circumstances to grant a stay application in favor of parallel proceedings. And in that case, they also cited to Reichold Norway v. Goldman Sachs, which dealt again with parallel proceedings, which is an opposite to the facts and circumstances of this case. Similarly, in Corinth Pipeworks v. Barclays, the court held that it had to consider application for adjournment in these circumstances with a degree of caution. But in that case dealt with a stay application in order for the third-party litigants to, quote, take stock of the litigation. And the court therefore had to determine whether that application would be an abusive process or vexatious, or whether it was justified to stay the proceedings in order to, quote, take stock. The court found that there were no new arguments or factual evidence to consider following Barclays' settlement with the claimant, Corinth Pipeworks. It was just an amendment of their particulars, which didn't need, quote, taking stock, and therefore the court had to proceed with a degree of caution. So based on the kind of legal principles extracted in the cases put forth before his lordship, the claimant's position is that the standard to be applied is still whether it is just and convenient in the circumstances of this case to grant a stay. In the claimant's application, specifically in the third witness statement of Mr. Jitin Shah, the claimant has put forward 3 points as to what justifies a stay application in this case. The first point was that the attendance or the participation of D2 to D4 would be crucial for these proceedings, and if the case was to proceed without them or without them having been served and their decision not to participate, it would not be in the interest of justice to continue. The first defendant has already expressed and proposed a stay of these proceedings in their skeleton arguments presented to the court before the CMC on the 20th of February. And here we refer to paragraph 14 of the skeleton argument, where the first defendant wrote that it is, quote, sensible to pause the proceedings until the situation with D2 to D4 has been clarified. The first defendant wrote that this is a fraud claim and should not be allowed to proceed in the absence of those that have perpetrated the fraud. Now, in the skeleton argument, the first defendant has, for the first time, changed its position in order to simplify this case and in order to vitiate the need for the second to fourth defendant by stating that the first defendant's position is that the claimant was not a party to the fraud and had no prior knowledge of any fraudulent activities. But that does not simplify the case or the first defendant's defense against the claimant's allegations, because there is still evidence to be elicited from D2 to D4 that their participation would be required to elicit that evidence in order to present the claimant's claims and also to assess the defendant's actions, the first defendant's actions in terminating the SBI facility. And here we refer to the statement of defense, which is the only submission that we have before us, since this new change in the first defendant's position has only come yesterday. But if we look at the statement of defense, we have at paragraph 45, which is page 33 in the PTR bundle. We have the main thrust of the first defendant's defense is that the claimant fraudulent activity or participation in the fraudulent activity or role in any fraudulent activity posed an AML risk for the first defendant in assessing whether the first defendant would continue with the to continue to have the claimant as a client of the first defendant, or whether it would suspend and terminate the SBI facility. It was not only this decision itself, but also the wider context of the claimant's role in any fraudulent activity. And here the first defendant has referenced 2 points. First, that it is unclear whether there was a false trade, i.e. whether the goods were in fact shipped and whether they were in fact paid for, that underlying or related to the fraudulent bills of lading, but also due to the claimant's role in changing its name as the co-signee instead of listing it as the bank. And under those 2 circumstances, the first defendant's position is that it posed an AML risk to the first defendant. And these 2 situations both involve the second to fourth defendant, and therefore it would be pivotal to hear evidence of the second to fourth defendant, or at least have them served to be able to attend the trial, to provide evidence on these 2 points. Further, the first defendant's decision or position that it was a lawful suspension and termination of the SBI facility is based on several grounds that relate to the actions of the second to fourth defendant. Namely, this is paragraph 52A of the Statement of Defense, which is page 34 of the PTR bundle, that the bank had a duty to suspend whether there was, in light of questions of fraud that were that had to do with the claimant's role in the transaction, but also the participation of D2 to D4 in the perpetration of that fraud. The first defendant has also said that the perpetration of the fraud constituted an event of default, and also that it constituted a change in circumstances, and that justified a lawful suspension and termination of the SBI facility. So we have these underlying allegations of fraud that are prevalent still in this matter, and the first defendant's change of its position in the skeleton argument does not change that. And therefore, the participation of D2 to D4 is crucial for these proceedings and their attendance in trial. And the claimant would also like to remind his lordship of his comments at the CMC. And here we refer to the transcript of the CMC of the 20th of February, where his lordship stated, quote, "It is self-evident that if these defendants are going to participate, it should be a trial involving everybody, because the facts are obviously relevant. The factual evidence is plainly relevant as to what your clients knew and what the other defendants say was the position in relation to the backdated bills of lading," and so on and so forth, end quote. So that is the first point, that the participation of D2 to D4 is crucial for eliciting evidence that will be relevant at trial, and it is crucial that they are that the case proceeds against all defendants. The second point relates to the efficiency concerns, namely that there would be a time and cost savings in staying these proceedings until D2 and to D4 has been served, and especially or alternatively in light of the Part 12 application filed by D2 to D4. And here we have 3 basically hypothetical scenarios that can occur. First, if the court hears the jurisdictional application and finds that jurisdiction is upheld and D2 and D4 are served before trial and they wish to appear, the parties will have to relitigate the matter, or at least have the D2 to D4 submit evidence, witness evidence, and expert reports, and the parties will have to reply to the witness evidence and expert reports in due course. And although this may bear costs or additional costs in having to relitigate certain matters, the claimant has been consistent throughout these proceedings that any cost consequences shall be borne by the claimant, but that can be obviously determined if and when that situation arises. The second hypothetical scenario that could happen is if jurisdiction is upheld and D2 to D4 decide not to appear at trial, then the claimant would the stay of the proceedings until service is effected is the most efficient outcome, since the proceedings will just be paused until D2 to D4 are served. They decide not to participate, and then the case will resume and a trial can be relisted at the earliest possible opportunity. So that would be the most efficient outcome. The third possible scenario is if the court finds that it has no jurisdiction and D2 to D4 are not served, then the claimant will have the possibility to decide whether to proceed only against D1. And if the claimant makes that election to proceed only against the first defendant, then the case will resume immediately, the trial will be relisted, and there will be no wasted cost. We cannot make a decision at this stage as to which of these hypothetical scenarios will actually materialize, considering the Part 12 application will be crucial in deciding which avenue the claimant will choose in proceeding with this case. The third and potentially most important consideration for the court is the due process rights of the claimant. The claimant has the due process right to bring claims against any or all defendants as it so chooses and in the manner it so chooses. If as the first defendant suggests, that the claimant should only proceed against the first defendant, that's not up to the first defendant or the court to decide. The claimant has the due process rights to bring the claims against all defendants as soon as and as practicable as it can. The claimant cannot be forced to proceed against the case only against the first defendant when there's several important matters that remain outstanding, including the issue of service. The first defendant has oddly created a request for a split trial that they've embedded in their skeleton argument, which we think is inappropriate to be included in the skeleton argument. But to address this quickly, to split the trial against, so basically to have concurrent proceedings against the first defendant and have a separate trial against D2 to D4 if and when they are served under the UAE PRC treaty. A split trial is not to split defendants. A split trial could be, for example, to address a preliminary matter or to split in effect a bifurcation of the proceedings, i.e. liability and quantum. It is not to force the claimant to split the trial to basically have two trials of the same facts and circumstances and the same issues present and have the claimant incur basically duplicative efforts and duplicative costs to bring two cases that can and should be heard together. Now, so those are the 3 points that the claimant has put forward as justifying a stay of these proceedings. On the alternatives or the counter assessment that the court needs to consider is, of course, the prejudice to the first defendant if the stay is granted. And here, again, we have 3 points to make. The claimant's first point is that up until the filing of the witness statement the first witness statement of Mr. Sumant Reddy, which was presented in response to the stay application, the first defendant has simply said that it stands to suffer some prejudice or substantial prejudice, but never particularized what that prejudice was. It wasn't until the submission of the witness statement of Mr. Reddy, which is available in the bundle at page 235, that the first defendant has raised 2 points of this potential prejudice that it stands to suffer. The first point that the first defendant has raised is that this application is late and that the claimant should have filed it sooner. The claimant is prepared to go through the chronology of the matter of service, but the fact remains is that the claimant remained in the dark of the status of service under the status of service in accordance with the PRC UAE treaty. The claimant, after the CMC on the 20th of February, where the judge made an indication that the service was not valid in accordance with the treaty, the claimant wrote to the registry the next day to inquire as to the status of the service in China, and then in the 3rd of May, when the claimant received a response from Hadith & Partners that expressly stated that the second to fourth defendant had not been served in accordance with the treaty, the claimant again wrote to the registry to inform them and to the court to inform them of this update and requested directions from the court. The court's only directions were to bring this email of Hadith & Partners to the attention of the first defendant, and that no further directions would be made at this time, and that any party is at liberty to make an application if it sees fit. At that point in time, the claimant was under the understanding that there was sufficient time in order for D2 to D4 to be served under the treaty, considering that all parties involved, including the court, had understood that it would take approximately 6 months for them to be served. So as long as the D2 to D4 were served before trial, the claimant thought that it was most sensible to wait to receive further updates from the registry. Between May and August 2023, the claimant wrote to the registry 4 times to request an update as to the status of service under the treaty. The registry responded that it was awaiting responses from the Ministry of Justice and that it would be in touch with the Ministry of Justice and it would wait and it would update the parties as soon as it heard back. In the final and 4th request of the claimant to the registry as to the status of service, the registry responded on the 15th of August, the next day, saying that the matter was pending before the Ministry of Foreign Affairs, and therefore the claimant understood that the service had not left the UAE and it had not even reached China. When the claimant received that email, the claimant understood that service would not be able to be effected before trial, and that's when the claimant made the decision to file the stay application 2 days later. The claimant's main interest in this case has been for D2 and D4 to be served validly before trial. That has always been the timing for the claimant's understanding. And as we discussed this matter at the CMC on 20th of February, everyone was under the understanding, and my colleague, Mr. Matu, had even said upon a question whether he was a betting man, whether they would participate. Mr. Matu's response was that, in his experience, they would not participate. So it was never a matter of whether they would participate or have enough time before trial to participate, but just a matter if service would be affected before trial. The second point that the first defendant raised in the witness statement as to the potential prejudice that they would suffer is that they will suffer wasted costs. That the first defendant has spent considerable time and money in instructing counsel and preparation for trial, and that if these proceedings were stayed, these costs would be wasted. However, a stay of these proceedings is not indefinite. The stays of proceedings is just for either the determination of the Part 12 application or until D2 to D4 are served. Once either of those 2 events are happened, the proceedings may be resumed, and any preparation or costs incurred by the first defendant up until the date of the stay would then be utilized and used for trial when it is relisted. These are not wasted costs. These are merely costs that will be deferred until the proceedings are resumed and the trial is relisted. The final point that the first defendant raised as the serious prejudice is that there's a serious impact on the business of the first defendant having this case looming over its head like Damocles' sword, and that there are serious allegations against both the first defendant and the employees of the first defendant. This is unfortunately a matter that happens in any litigation, that there are allegations that remain outstanding, and if these will remain outstanding until there's a final resolution of the dispute, and there's no reason to warrant against a stay of the proceedings. So on the basis of the grounds that justify a stay of the proceedings and the fact that there will be no unfair prejudice to the first defendant, the claimant's position is that the stay should be granted.
Thank you very much, Mr. Cotty. Let me just ask you one question. In circumstances where the first defendant says it is prepared to proceed on the basis that the claimant was not involved in the fraud, then the whole factual inquiry into the bank's reasons for doing what it did simply centre on what its understanding was at the time. The actual facts that surround the fraudulent bills in terms of your client's participation have no relevance at all. So what is the problem in relation to needing the other defendants to be present, even assuming for the moment that jurisdiction issues are overcome and they decide to participate?
There's 2 points there. The first point is that the first defendant's position thus far in these proceedings, until the skeleton argument was filed last night, is that the claimant posed an AML risk, and that had to do with the fraudulent activity, not necessarily the fact that the claimant perpetrated the fraud, but that now they're saying that the account was suspicious and that the account was tainted by the fraudulent activity that occurred. This AML risk and the bank's perception of the AML risk and the bank's decision to take action based on this AML risk is based on the fraudulent activity that occurred. It is important to understand whether D2 to D4 expressly acknowledged that they were responsible for the fraud, and also to provide further context, as I mentioned, at the circumstances surrounding the fraud. So it is not only the backdated bills of lading or the fraudulent bills of lading that caused the first defendant to make the decision to suspend and terminate, but it was also the wider risk that they had assessed, namely that whether this underlying trade was a false trade, i.e. whether the goods were actually shipped and actually paid for, or whether this was a completely fraudulent transaction. So this was a transaction with the claimant and D2 to D4, and the claimant, it's very well can exhaust its position and say that this is the transaction did go through, but it would corroborate what the claimant is saying, that the transaction was a real transaction, that any fraudulent activity was just that of D2 to D4, such that the conclusion would be that the AML risk allegedly posed to the bank was not an AML risk at all, and therefore there was no grounds for termination. So it would be corroborating evidence to the claimant's position that not only was it not involved in the fraud, but there was no reason or no wider context that the claimant posed an AML risk to the first defendant.
But what matters in this context is not what the facts were, but whether the bank had justified suspicions in the context of AML and what, as is common ground between the claimant and the first defendant, were fraudulent bills. It's common ground between you two that Mr. Chadwick's clients were fraudulent, isn't it?
Yes, that's correct. But to the original point of his lordship is whether they were justified. That justification can only be presented based on the facts and circumstances between the transaction of between the claimant and D2 to D4, but also D2 to D4's actions vis-a-vis drawing down on the letter of credit. So the participation of D2 to D4 in the overall transaction are relevant to determine whether the first defendant was justified.
All right, thank you very much. Mr. Chadwick, do you want to put in your 2 pennyworth at this stage? I don't really see why you should, but nonetheless, let me hear from you to see if you've got anything helpful to say.
I'll be very brief then. We think that it's just on a procedural or slight semantic ground. It shouldn't be a stay. If you are minded the grant stay, it shouldn't be a stay. It should be an adjournment of the trial date. The reason we make that distinction is a general stay. It's a general stay of the whole proceedings, and I don't think that's appropriate where we've got an application, Part 12 application, that's still to be heard, to be signed. And there's also arguments about time running where they haven't made any application to extend the validity of the claim form. And a stay would possibly be an argument that that time doesn't count from when you granted the stay. The fact that they haven't made any application, even that's up to today's date, for an extension of the claim form, they need to justify why they haven't and why they haven't done it right up to today's date, despite numerous, from what we can see in the file, indications to them that there has been no service. Yet they've never made an application to extend the claim form, and that expired a long, long time ago. Even if they take the argument, I
understand that. I think the I had understood the application for a stay to be simply a stay of the claim as against the first defendant until such time as matters were resolved as between the claimant and the second to fourth defendants in terms of jurisdiction. That I think is the point you have to meet. So I don't think there was any question of the claim being stayed against you. So all bets are. Everything is open to you to argue in relation to jurisdiction and late service and failure to extend time and so on and so forth. But I take it, Mr. Chadwick, that you have no instructions to tell me whether should there be valid service, whether that were to be decided as having taken place or were to take place in the future. I take it you have no instructions to tell me whether or not your clients are going to participate in any trial.
We have no instructions about whether we will be filing acknowledgement service following a valid service taking place.
Right.
My only point on that would be that we have an absolute discretion whether to do so or not. At
Yeah,
the
yeah,
moment,
yeah.
I can't.
No,
At the moment, I
understand.
have no instructions. No instructions on that.
Yes. So that if one looks at this realistically, and assuming that the view that I'd already formed that courier service was not permissible in China, the reality of the matter is that any trial that involves your clients, should they choose to participate after valid service and file an acknowledgement of service, we're looking at a trial in something about 18 months' time at the earliest.
I think
Is
that
that
must be right.
is that a reasonable proposition?
Yes, I mean, when there is valid service, we would have, under the rules, 45 days to acknowledge service. Then we would have to do a lot of catching up on the pleadings and depends go through all the stages of including what probably is going to be extensive disclosure. I would guess 12 to 18 months is probably a fair assessment.
Yeah. Mr. Kotick, I need to ask you about that point, because that does seem to me to be logically the outcome, at least on one of the potential courses of action that you've outlined. Do you think that's about right, realistically?
If just to determine the amount of time that would be required to involve those defendants in the case, sure. That, I mean, that sounds like a reasonable amount of time. And as far as any prejudice to the first defendant and waiting for this catch up, as far as time is concerned, we don't think that would be any unfair prejudice to them. Their only concern is that there would be hanging allegations against the first defendant and allegations against the employees of the first defendant, but that would not be a reason to establish any prejudice. And as far as wasted costs, we can consider or additional costs that would be required to relitigate these matters. That would be something that the claimant would take on if and when that arises.
Well, it will arise, won't it, on this basis, because there are inevitably going to be costs if there's an adjournment.
Yes, but the claimant will,
regardless.
If the second and fourth defendant are served, and if they decide to participate in these proceedings, and if it comes to light that it would take 12 to 14 months to continue with this case against all defendants, then the claimant will have the right to consider whether it wishes to face those additional costs or to whether proceed only against the first defendant. It would be the claimant's right to decide how to proceed in light of the events, if those events were to transpire.
Right, Mr. Friedman, I've read your skeleton, so I don't need you to take me all through it, but are there particular matters you want to highlight in the context of what's been said this morning?
Well, I'm grateful, my lord. I'll skip through a lot of what I was going to say, given that indication. But essentially what we say is that there are a number of procedural routes, a number of ways of skinning the cat by which my lord can get to what we say is obviously the correct conclusion, which is that this trial should go ahead, and that we shouldn't be forced to suffer all of the prejudice, both in terms of cost, but also more generally in relation to the impact on my client, its business, and on the individuals working for it. What I propose to do, but as I say, given the indication, I'll try and skip through it. I just wanted to pick up on some of the relevant facts, briefly respond to my learned friend in relation to the principles, and then I'll deal with the three separate routes of skinning the cat to get there. And to summarise, those three ways are that the first and most straightforward point is that the issues are distinct, and that therefore the trial should continue as presently ordered, as against us, and whatever happens against D2 to D4 can follow at a further point. And so whether that be characterised as a split trial or otherwise, that is, in my submission, the appropriate way of doing that. And just to pick up in the introduction, the error that my learned friend, Mr. Kotick, makes in his submissions is my lord picked up in the questioning with him, is to confuse the question that is actually going to be decided at the trial. Given what we say, that we're not going to say at the trial in September that they perpetrated the fraud or knew of the fraud in advance, the question is about what the bank knew at the time and whether its reaction was appropriate. And therefore, that does not require an examination of whether or not the claimant was involved in the fraud. It doesn't require an examination of whether there was a fraud, because that is common ground. And my learned friend, I'll go to the pleading subsequently, but where he dealt with the AML concerns, we do say that they're an AML risk, but they're an AML risk based on the agreed fact that there was a fraud involving a bill of lading, which we're not saying was perpetrated by the claimant. And in those circumstances, it's about the fact that the bank reacted appropriately and in accordance with its duties. And that has nothing whatsoever to do with D2 to D4. So that's the first and most straightforward reason. The second reason is that I do say the court can look at the matter now and determine that there is no remaining claim against the second to fourth defendants. The claim form has not been extended and it has not been served. And Mr. Kotick is required to ask the court to stay or adjourn pending a claim, which claim does not exist anymore. And so in my submission, that precludes the order that they seek. But in any event, it's part of the court's discretion. And if the court is asking itself, well, is it right to cause all of the prejudice that there is in favour of what is an entirely fanciful suggestion that this can be pursued based on an out-of-time claim form that hasn't been served, then in my submission, that makes the original point all the clearer. And thirdly, we do say that KIRTANLAL can be put to its election. And again, I'll come to it in a little more detail, but I was a little bit surprised to hear my learned friend say that that it is not up to the court to decide when and how the claimant can pursue its claims. In my submission, it rather is up to the court to decide. And the court can, and if need be, should put the claimant to its election. And indeed, the claimant has already elected. But that is a difference of position between my learned friend and me, that I do say it's for the court to decide. And it perhaps explains why we are where we are, given that the claimant seems to think that it can decide unilaterally and as it chooses. So just by way of introduction, just to pick up on the relevant chronology, and again, I'll deal with this very quickly, given my lord's indication. But it's simply to make clear that the claim form was issued on the 13th of June of last year and hence expired on the 13th of December of last year. It was on the 29th of July of 2022 that the claimant put in certificates of service for the CITIC defendants, claiming that they had been served. And again, for time, I won't go to the bundle. I do have references, obviously, if it would assist. So please, Josh. But that certificate of service said that service was effected by courier or alternative service which provides for delivery on the same or next working day. So service was said to be by courier. Our defence was put in August. Their reply was in September. We then had the CMC before His Excellency Nasir al-Nasser on the 18th of November. Now, in the run-up to that, there was correspondence about service. And so service came up at the CMC, where, again, the claimant maintained that service had been affected by courier. And we had Mr. Tanwiri's statement put in on the 21st of November to the same effect. We then came before my lord on the 24th of January. And again, the claimant maintained that service had been affected by courier. That brings us to the February hearing on the 20th of February, again before my lord, where my learned friend Mr. Holloway appeared, and he addressed my lord in some detail on that issue. And if I could ask my lord to pick up in the bundle, I don't know whether is my lord working electronically, in which case I'll just give the page number, or to Tab's help.
Well, give me, but I've got the caseline system up. So
okay, so this is at G tab 2, page 407.
Hold on. Sorry, bear with me.
Of course.
Search function doesn't seem to be operating, but anyway, there we are. 407 you want.
Yes. So do you have at the bottom of the page where it says Justice Jeremy Cooke?
Present, I'm just on 387. Hold on, why isn't it going on? It's like I've got to scroll down rather than putting in the search function. Never mind, I'll get there. I don't find this new system as user-friendly as the last system that the court had. Anyway, there we are.
Yes,
we're on 407.
Yeah,
407
I'm slightly struggling too with this navigating the bundle. So,
has anybody been making representations to the court about this? I've complained.
I'm something I can pick up.
Well, if other people are having difficulty, the court needs to know. I mean, I find a number of defects with this current system that I'm not very happy with. You get the case bundle, and you either have to download the lot, but you can't download or print individual pages from the bundle, which I find unhelpful, because normally one wants to print off hard copies of crucial documents and have everything else electronically. Anyway, all I'm saying is that if you as users have issues with it, the court needs to know, because it can improve the system. So please feel free to do that in a polite way, please. Anyway, there we are. Page 407.
Yes.
I'm finally there. Yes.
Very good. So it's at the bottom of the page where my lord says, it's very clear to me. Yeah. One, that service by courier is not a permissible method under the law of China. I've come across this before in any event. Two, I'm going to need to have a witness statement which explains the up-to-date position and exactly what it is that the claimant says the position in relation to the service through the judicial route, and what they've been told about receiving some confirmation that service has been effected through the judicial route. Then my lord goes on to say, I'm bound to say it does not seem to make much sense that you did not get any acknowledgement of that once it's been done. And that was because it was being suggested by the claimant that it might have been done, but they wouldn't have heard about it. And then my lord says, China, I know, is different from elsewhere in COVID. Then says, I'm speaking historically. And then says, I'm going to need all that set out in a witness statement, Mr. Matu. If you feel you can serve proper certificates of service, there will have to be new certificates of service, because those that refer to service by courier simply do not cover the position correctly as a matter of analysis of Chinese law. And so in my submission, the court has already determined that those certificates of service are not valid. That was what my lord decided there. And the requirement for a witness statement was specifically in the light of that determination, where my lord was saying, well, the courier service and those certificates of service are not valid. If you want to say that there has been service, it has to be by the judicial route. And so I need a statement setting out the point that they might have been served without you, the claimant, being told about it. But of course, that point has dropped away, because it's now common ground that under the judicial route there has not been service. So that is why in my submission there is nothing left for the claimant. My lord has determined that those original certificates of service were not valid. My lord has said that if service was to be said to have been effected, it needed new certificates of service based on the judicial route, and there are no new certificates of service, and it's common ground that the judicial route has not completed. And I do say that that is relevant background. I'll come back to that. Then the other point is just to skip over the fact which I imagine my lord has well in your lordship's mind, that of course the situation has moved on very substantially. There were at that point there had been pleadings such as they were, but there had not been the completion of any steps to trial beyond that. The history, of course, is because the pleadings were, as my lord said, outrageous. There had then been a schedule. We'd served our counter schedule in accordance with the timetable 6 days before the February hearing. So then we got to directions, and those were put in place by my lord. And we therefore had production. The process for that started in March, completed on the 8th of May. We had witness statements on the 23rd of June, reply statements in mid-July. And as I flagged in my skeleton, though the witness statements raised important new allegations of wrongdoing. I've set them out at paragraph 9 of my skeleton. But for example, the allegation against Mr. Shenoy, who is a finance professional, who's the CEO of a significant bank, where the allegation is made that he, and it can only really be read as deliberately misled, that he deliberately misled the regulator, is a very serious allegation indeed, made in the witness statements and made against him personally. And so that is another matter that has happened. We've then had the expert report, the 19th of July, from them claiming a loss of $18.5 million. You have our experts in response in August, obviously saying that that's not right. And then we have the joint memo. And then there's this small issue about the date of the reply expert reports, which we'll come to if my lord is with me, that the trial should not be adjourned. But either way, those will be this week on either party's proposal. And all of these steps took place prior to this suggestion made on the 15th of August that there should be a stay. And the next relevant background point, of course, is the lack of a request for a stay, a lack of an application, a lack of any suggestion that there would be a stay. Now, as I've set out in my skeleton argument, my lord indicated my submission quite rightly at the February hearing that as a matter of common sense, it would take at least 6 months from service for D2 to D4 to be part of a trial. And indeed, as been canvassed today, given the nature of the allegations, it will almost certainly be longer. But the point being that this was in the context of my learned friends suggesting at that hearing that somehow service had been affected by the judicial route, but there just hadn't been a notification, i.e. the time had already started. And then what happened was that it became perfectly apparent that service had not been affected. Now, again, I've set this out in my skeleton argument for completeness. It's pages 507 to 508 of the bundle. But what happened was that MB Kemp wrote to the court on the 3rd of May, saying that the CITIC defendants had corresponded with them to say that they hadn't been served. And the CITIC defendants said that the court should proceed with this case only against D1 until they'd been served in accordance with the treaty. And my lord responded to this by saying, well, I'm not going to make any directions. My submission quite rightly, but saying, well, look, if you want to make an application, make an application. And what happened was the claimant declined that invitation to make an application. And in my submission, by this point, on the 3rd of May, it was blindingly obvious that there was no way that a trial could take place with D2 to D4. And that if an adjournment had been wanted, an application should have been made no later than then. And again, for time, I won't go there. But again, we have in the bundle that on the 17th of May, confirmation was provided and it was passed on by the claimant that the CITIC defendants still had not been served by the judicial route. So again, by that point, the claimants knew that not only did the CITIC defendants say that they hadn't been served and that the claim should proceed only against my client, but that in any event, it was confirmed by the authorities that the judicial service had not taken place in mid-May. And again, no application was made. And then the final point really in the chronology is, of course, for Mr. Chadwick's application. And that application is put on the grounds that were already dealt with at the February hearing, which is that service by courier for ineffective and the time for the claim form has expired. And so what we have in my submission by way of summary is that we have a claim that is on the eve of trial. We're under 3 weeks away from skeleton arguments, less than a month from trial. We do have, as I'll come to, substantial costs incurred. The claim is in fact ready for trial, and we have the claimant not having taken any steps to seek an adjournment at an appropriate moment. So that's the background. Turning to the principles, those were set out in my skeleton argument. Now, my learned friend sought to take a point on the investment group case and said, well, the test is what's just inconvenient in all the circumstances, or doesn't need to look at whether it's rare and compelling. The first point is they don't meet the standard on either ground. But just to pick up what he said, and this is at page 557 of the bundle. This is the investment group case.
Yes.
And so if one sees at paragraph 76 of that case, I guess mine's just loaded. So what is said at paragraph 76 is that the parties don't disagree that, as was held in Reichhold, a stay would be granted on case management grounds only in rare and compelling cases, and that the burden of proving that this is such a case falls on the party seeking a stay. And then the court says the only case management consideration which IGPL has pointed to is the existence of parallel proceedings. So the court isn't saying that it is the rare and compelling test applies only in the case of parallel proceedings. The court sets out the rare and compelling test and then says the only point that's been noted as being relevant to that test is the fact that there are parallel proceedings. So of course it is right, and of course every case turns on its own facts, but and it's right that that was a case involving parallel proceedings, but the court didn't put its decision on that basis. But as I say, in my submission, I don't think this should really trouble my lord, because I do say that whether it's just and convenient or rare and compelling, then the test isn't satisfied. And I do say that this all falls within the ambit of looking at what the overriding objective requires. That requires that a case be dealt with expeditiously. Of course, imposing a stay or an adjournment makes it less expeditious. And also that there is a need to allot an appropriate share of the court's resources to a matter. When there is an adjournment of a hearing, that will waste resources. There's also a requirement to deal with a case in a manner that saves expense. Again, adjourning a hearing will naturally cause wasted expense. And I just want to pick up on one point, and again, I will come back to it briefly, but just by way of introduction, Mr. Cooke said when he made his submissions, well, there won't be any wasted costs. There will only be deferred costs. That isn't right. But in any event, I do note that when he was then questioned by my lord on it, he did accept that there would be wasted costs. So I then turn to the substance, and as I say, I've set out my 3 bases that I summarised at the beginning. So the first one is that the issues are distinct, and so simply as a matter of case management, it continue with the trial as ordered, and then the other issues could, if they ever fall to be determined, would be determined at a subsequent trial, and that would deal with matters expeditiously. It would allot a fair allocation of the court's resources and save costs. My lord has already dealt with Mr. Cooke and indeed Mr. Chadwick, that there would be a very substantial delay. Now, Mr. Cooke said, well, you don't know whether there would be the 18 months to trial. It may just be the jurisdiction challenge. But either way, it would still be a very substantial delay. And indeed, it's not just that the jurisdiction challenge would have to be determined, but the trial would then, even if it was only just against us, it would then have to be relisted. It would need to be done in relation to counsel availability. Inevitably, the way things are with these things, that could take a very substantial period of time. For my part, I mean, I have a 3-week trial in November, an arbitration in March, and then a 6-week trial starting in June. So my diary does not have much availability, if at all, beyond the trial window. The next point is that this is a case that is ready for trial. The court, in my submission, should be very reluctant to adjourn such a case. The parties have prepared, the court has set aside the time. Our witnesses have made arrangements to come to the jurisdiction to be cross-examined and to be available for the court. So all of these are substantial inconveniences. Now, my learned friend dismissed the point, said it didn't matter that there were serious allegations against the bank and against its employees. In my submission, that's not right. He's correct that, of course, that while a matter goes to trial, you have to wait for your vindication. But that's a different point to saying that one should adjourn an already listed hearing, or saying that it wouldn't be prejudice to us to require us to wait very much longer. And as I say, these are at the most serious end of the allegations that have been made against finance professionals and against a bank that relies on its reputation to win its customers. So I do say that that is a substantial factor. Mr. Reddy had also explained in his witness statement that it's causing substantial ongoing disruption to the bank's operations, unsurprisingly, and that is, again, in my submission, material prejudice. Now, in relation to this point about wasted costs, where my learned friend Mr. Cottick said that they said at first, well, there won't be, and then said that there would be, it's entirely unsurprising in my submission that there are going to be wasted costs, given that we are on the eve of trial. Now, they fall into a number of categories. There's, for example, costs such as my brief fee, which is irrecoverable to the client. There is the cost of preparing the trial bundle, which, been undergone, that would have to be entirely redone. These are the kind of things that happen when you adjourn a trial. But secondly, in any event, there are going to be substantive matters that have to be redone. I've given the example in my skeleton argument of the experts. Their analysis will, by the passage of time, will become outdated. Of course, the loss is always calculated up to the date of trial, which is what has happened. If trial takes place 6, 9, 12 months, 18 months down the road, the experts will have to redo all of their work, redo the joint statement, redo their reply reports. And then, of course, we are waiting to be repaid our costs because we say our defence will succeed, and so we're going to be kept out of our money. And so we do say they should be split. And then really, Mr. Cottick tried to come up with this suggestion that there would be that somehow this covers the same facts and circumstances. Now, I've already set out in my skeleton argument that that's not the position that he has adopted at any point, where they've made clear that they're entirely distinct. And just to pick up on if we may, in the bundle, which is at page 33, which is where he referred to our defence, and he tried to say that there'd be an overlap. Does my lord have that?
Which particular paragraphs are you
Paragraph
directing me to?
45.
Yeah, I'm looking at that.
Yes. So what we're saying here is the bank had a right and duty to review the claimant's compliance risk, including its AML risk, and it duly assessed the relevant risks in accordance with the policy. And the bank was satisfied, taking due account of the claimant's explanation of events and all relevant considerations, that the circumstances had increased the claimant's compliance risk. And it then sets out what the bank's understanding was. The point in relation to AML, as I prefaced earlier, is that this is about the bank's understanding. It is common ground between the bank and the claimant that there was a fraud. And so it is whether the bank was right to react as it did. And the point is, because of what we've made clear, we're not saying at September trial that we were right to act as we did because the claimant acted fraudulently. We left that open in February, but we're not saying at the trial that was a reason. And so that simply deals with my learned friend's point, and there is no overlap. And then he referred to paragraph 52 of our defence, and all that says is that the decision to suspend the facility and later to exit it was taken in accordance with the regulatory duties and in accordance with the facility agreement. So again, it doesn't take my learned friend any further. And it is worth, in my submission, also just briefly looking at page 204 of the bundle, which is Mr. Tanwiri's third statement.
Yeah.
And it says that paragraphs 43 and 51 of the particulars of the claim, the claimant has provided the causes of action for the claimant's claims against the second to fourth defendants in the present DIFC proceedings, arising from the wrongful actions of the second to fourth defendants. These claims are strictly against the second to fourth defendants and are not pleaded against the first defendant. And that is right. I've set it out in my skeleton argument, where what the claim against the city defendants is about whether they were involved in putting in place fraudulent bills of lading. They are not claims that are brought against us. And again, I've mentioned in my skeleton that at the February hearing, it was said by the claimant that the claims against D2 to D4 do not concern D1. So they are different claims that can be determined separately. And my learned friend has been unable to point to any point that would require everything to be dealt with together. So then what's said against it? Again, I've dealt with them in detail in my skeleton at 28 to 39. So I'm not planning on going back to them in any particular detail. Just to pick up on this point about what we said at the February hearing, it is, with respect to my learned friend, an entire jury point. It's a jury point because what it does is it doesn't engage with the substantive question or whether it is right or whether it is not right to impose a stay. It's simply saying, well, you previously said something else. And of course, the same charge could be laid at my learned friend's door because they opposed a stay in February. But the more pertinent point is that we are not in February and matters have moved on. It's moved on for the 5 reasons I've given in my skeleton, because we've incurred all of the costs. The matter is now ready for trial. We're on the eve of trial. We've explained that we're not going to be saying at the September trial that the claimant perpetrated the fraud. And so, and the 5th point is that they haven't sought a stay earlier. So we're in an entirely different position. So it is a jury point, but it's also not a very good jury point. Mr. Shah says that the merits will have to be relitigated, and that there's a risk of a vacation on short notice. Well, the merits won't need to be relitigated because the points don't overlap. And then it's rather curious that he says vacating the trial at short notice is a bad thing, and so that should be avoided by vacating this trial at short notice. In other words, their proposal would create the very prejudice that they say is a bad thing. The next point is to say that a judgment would not bind the second to fourth defendants. That is correct, but that's a point in favour of allowing the trial to go ahead, not against it. The 4th point relates to default judgment, which falls away, given that the jurisdiction challenge has been made. And then the 5th point was the point that Mr. Cooke made, which was to say, well, the court can't decide, we can. And as I've already dealt with that, that's not in my submission the way things work. So that's why we say there should be no stay or adjournment. But my second way of skinning the cat, and in a certain sense it feeds in as an additional reason, is the point that I prefaced, which is about the fact the court's already determined, and indeed it's plainly obvious, that there's not been service. I've gone to the transcript. Given that, I don't propose to go back to all of the Chinese law provisions. They're in my skeleton argument. Indeed, they're in Mr. Chadwick's application, where he summarises them too. But the simple point is there has been no application made to extend time. Time has plainly expired, and my learned friend accepts that there has not been service, and indeed he hasn't suggested any basis on which there could have been service. So how could the court possibly adjourn this trial in support of a claim against the second to fourth defendants that doesn't exist? And indeed, I do say if required, in my submission it's not required, but were it to be required, the court could summarily determine that that is the case today. And then my third way of skinning the cat is that as a matter of case management, it is too late for the claimant to ask for what it's asking. The court made clear at the February hearing that the claimant would at a certain point be put to its election. I've dealt with the timeline. That point plainly passed, certainly no later than around the beginning of May, but in my submission far earlier than that. It is therefore far too late. It is readily apparent from how the claimant conducted itself that it continued on the basis that it would proceed only against the first defendant. So as I say, there is no need to go this far in my submission, because the simple point is the court can simply say the trial proceeds in September and deals only with the claim against the first defendant, and everything else can be pushed off. But to the extent the court were to be concerned about it, the court can and should determine that the claimant has made its election, or indeed that it would be required to discontinue in order to maintain its claim against us at all. And there's no prejudice to that, because if the claims get discontinued, the claimant can issue again against D2 to D4. The only thing it will lose is its claim form and its pleadings, which my lord has already described as outrageous. So I don't, and indeed against us, they had to replead anyway. So there would be very little that would be lost there. So, so my lord, for all of those reasons, I do say that this is an application that has no merit whatsoever. There is the strong suspicion that this is a tactic of a client that threw everything at the wall in its, as it accepted arbitration style pleadings, but then it just simply has not stood up to the rigor of document production, witness statements and experts. And what is happening is that they are trying to kick this off to either put more pressure on us, because we will incur substantially greater costs. Our clients, my client and its employees will have the concern, the business difficulties with having to wait for vindication. So they're hoping it will try and push us into a settlement of their bad claim, or maybe they're simply hoping that something will come up in the additional time that they get. But it's not a good reason for a stay or an adjournment. So on any one of the three ways that the court can get there, in my submission, plainly the test is not met, and that the court should order that the trial against my client should go ahead within the current fixture in September.
I asked both Mr. Chadwick and Mr. Cooke about the length of time that could be involved were the second or fourth defendants to be involved in any trial. If one works on the basis that the claim form has not been renewed, and that in accordance with what I decided earlier, courier service has not been validly affected as a matter of Chinese law, and therefore for the purposes of the DIFC, is it open to the court to extend time on the claim form ex post facto? My recollection is there's room to do that, but you do it only in certain limited circumstances. And then the question arises as to whether or not service by the diplomatic judicial route, however one wants to describe it, has to start all over again, and therefore what the impact of that would be on any trial date involving the second to fourth defendants, assuming they decide to participate after any valid service. I don't know whether you've thought about that and got any submissions to make on it.
Yes, yes, I have, my lord. So it's rule 720 to rule 723 deals with the service of the claim form an extension of time. So yeah. 720 sets out the time period. 721 says that the claimant may apply for an order extending the period. 722 says that the general rule is that an application to extend time must be made within the period, which obviously hasn't been done, or within the extended period. And then 723 deals with the position where an application is made afterwards. Says the court may make such an order only if the court has been able to serve the claim form, or the claimant has taken all reasonable steps to serve the claim form but has been unable to do so. And in either case, the claimant has acted promptly in making the application. So in my submission, the claimant has not acted promptly in making the application because time expired in December of last year. And there's no application before the court now. So it's at least 8 months out of date, even if it were made today. There would also be a question as to whether all reasonable steps have been taken to serve the claim form, given that it's the, as I'm sure my lord's well aware from the English authorities, you don't take into account any delay due to error on the part of the serving party. So when you try and serve by one method, and that's an ineffective method, that doesn't count as a reason why you took more time. And so given that they focused initially on courier service, that would also count against them. But in any case, in my submission, it can't possibly be said that they have acted promptly, and therefore that requirement is not made out. Now, I do accept that obviously that leads to a further delay. What would need to happen would be there need to be a new claim form issued, new service affected. I accept that that may take 6 months, and then there would need to be a question of we would need to see whether jurisdiction was accepted or not by the CITIC defendants, and then it would need to go to trial, and that would take, in a fraud claim, at least a year, probably 18 months. So we may be looking at 2 years all in for that to happen.
Well, we're bound to be looking at 2 years if it's going to take a year to serve in China, which is the current experience.
Yes.
We start all over again. It's going to be a minimum of 2 years, assuming there is valid service and the second to fourth defendants choose to participate. And in reality, more like 2.5 years.
Yes.
May we provide our submissions on this, my lord?
Yeah, don't worry, you'll get your chance, Mr. Kotick. Don't worry. You get a right of reply. Anything else you want to say, Mr. Friedman?
What I would say is that if my lord were against me on the substance in terms of stay adjournment, I'd obviously want to address my lord on what happens next. But in my submission, we shouldn't be in that territory. But no, so I think it just reiterates that whatever way this happens, the delay is going to be very substantial indeed, and that obviously is a substantial prejudice to my client. But otherwise, my lord, those were my submissions.
Yes, thank you.
Thank you,
Mr. Kotick.
Thank you, my lord. We'll address our reply in a different order, but I'll make sure to flag where we're going. The first point is obviously this Rule 7.23 for the retroactive application for an extension of time for service. To address the 3 points that are that follow the elements of 7.23, that the court has been unable to secure the claim form or serve the claim form, which is true, or the claimant has taken all reasonable steps to serve but has been unable to do so. And my learned friend has kind of skimmed over the facts and the chronology of this case. The fact is that on the 15th of June 2022, the claimant served the Zonglun law firm by courier, and on that same day, the 15th of June 2022, it wrote to the registry for service under the PRC UAE treaty. So that the claimant wasted no time in initiating initiating service under the treaty, and in fact, it did both at the same time as a sort of belts and braces approach, something that His Lordship found sensible at the CMC hearing at the 20th of February. Since that time, in the 15th of June, the claimant has been in the arms of the registry and the Ministry of Justice in making this service. The claimant made attempts to contact the Ministry of Justice and the Ministry of Justice in China, and was told that they would not be communicating with us directly, and therefore the only role that the claimant could play is to just request an update on the service from the registry, and that the registry would provide us updates accordingly. The claimant proceeded to consistently request updates from the registry to find out what the status of service was, and it wasn't until the 15th of August email that the claimant knew that that service was still with the Ministry of Foreign Affairs. Now, it is not right, as my learned friend says, that we have to start all over again with service. The service is pending with the Ministry of Foreign Affairs, and it can continue with service to China. And in our conversations with the Central Authority of China, once it reaches China, it should only take approximately 10 days in order to serve, obviously depending on the region at which it needs to be served. So it's not a matter that this is going to, take a protracted period of time. We thought this would have been 6 months from the 15th of June when we initially sent the request to the registry to serve under the treaty, which would have brought us exactly within the 6-month time period for effecting service outside of the jurisdiction. And now we're in this period with no information or updates from the Ministry of Ministry of Justice or the Ministry of Foreign Affairs on when this will happen, but it is with the Ministry of Foreign Affairs as per the registry's email of 15th of August. So the next step that needs to happen is that it goes to the Central Authority of China, and then on the Central Authority of China's own communication with us, it would take about 10 days for service. So on that basis, we think that there is a justification for a retroactive application for an extension of the period of time for service. But all of these issues will be ventilated in the exchange of submissions in response to the Part 12 application. And therefore, on that basis, these needs to be discussed between the parties and submissions need to be exchanged. And that will affect the trial dates that are listed as of now. So those, and this is what the second to fourth defendant had approached to us, and we approached the first defendant to seek their consent to, at the very least, vacate the trial dates as they are currently listed in order to allow for this application to be vetted and ventilated properly so that the parties can express their views. It's not the purpose of the PTR hearing to go through the parties' submissions here and make a determination on this, since we have a right to submit submissions in this regard. Now I would like to go back to just some of the points raised by my learned friend as far as the justification for or and against the stay. The first one, I would like to bring his lordship back to the statement of defense, which is specifically paragraph 45, which his lordship was brought to earlier. This is on page 33 of the bundle. And my learned friend addressed the main paragraph 45, but did not go into the sub-paragraphs, which are actually more relevant for the purposes of describing that the factual circumstances are overlapping between all defendants. So paragraph 45 addresses the bank's right and duty in the circumstances to review the claimant's compliance risk, including the AML risk. And in that assessment, we look at paragraph 45A, and it said, on the basis of information received from the IMB, it was the bank's understanding that this was an entirely false trade to the extent that the goods were not shipped on the vessel stated in the falsified bills of lading, yet the claimant continued to maintain that the goods had been shipped on the vessel stated. So here we're going to the bank's understanding of the AML risk posed by the alleged AML risk posed by the claimant. And the bank's understanding was based on their interpretation of the IMB report that this was an entirely false trade, that the goods were not shipped, and that the claimant maintained that the goods had been shipped. So whether the goods had or had not been shipped can be obviously claimant, but these are facts and circumstances that will be pleaded by the second to fourth defendant. And then in 45B, it says, as appears from paragraph 38 of the particulars of claim, the claimant caused the revised bills of lading to be submitted by the fourth defendant through Mashreq Bank to itself as a consignee on a collection basis, rather to the bank. This raised a further doubt, given that the bank was the correct consignee in the letter of credit, and it was unclear to the bank at the time whether Mashreq had been made aware of the full background. So we have in the statement of defense, we have that the first defendant's pleaded case as it stands is that the claimant caused the revised bills of lading to be submitted by the fourth defendant. So the evidence to be elicited from the fourth defendant is how these bills of lading were submitted to Mashreq Bank and the reasons to include the claimant as the co-signee on the collection basis instead of the bank. I further would like to take you to paragraph 52, which my learned friend again only addressed the heading, but it's more illuminative if we go through some of the subpoints listed in the statement of defense. This is at page 34 of the bundle. And if we go to 52A first, it says that the bank had a duty, including the duty to the claimant as its customer, to suspend the facility for so long as there existed a question of fraud potentially impacting the drawdowns under the facility. So this position taken by the first defendant in the statement of defense is not the position they've taken today. So we're in a situation where the defense needs to be amended if the first defendant is going to continue with its new theory of its case. If we go to 52E, we have pursuant to 14.2C of the restated facility agreement, the bank was entitled, upon the occurrence of any event of default, to declare any unutilized portions of facilities to be canceled. And this occurrence of any event of default relates to the allegation of fraud and that the claimant participated in this fraud, and that the participation in this fraud was actually contrary to law. And therefore, we have again the statement of defense clearly pleading that the claimant was included in this in the fraudulent activity, and on this basis, the bank made the decision that there was an event of default and therefore was entitled to terminate the contract. So we really don't have a clear pleadings from the first defendant in light of the new position that the claimant was not responsible in the fraud and had no prior knowledge. I'm going to turn now to the timing of the application that my learned friend raised, specifically relating to the claimant's previous position that service had been affected. In looking through the transcript of the CMC of 20th February and the witness statement submitted 1 week after on the 27th of February, the claimant did say at the CMC that if his lordship remembers, that said, for our purposes, service had been affected, and upon further questioning on what that means for our purposes, the claimant made it very clear that that was on the basis that the service had been done via courier and that it had made all attempts that it could to affect service through the treaty. Since then, the claimant has not been able to take any further steps because it was out of his hands. It was with the registry and with the Ministry of Justice to continue that process. So although it was clear that service via courier was directed by his lordship of not being in accordance with Chinese law, the claimant had initiated service in accordance with the treaty, and therefore thought that if service by courier was insufficient, that the process in parallel was already progressing, and that it expected that this process would be completed within sufficient time before trial to not affect any have any impact on trial, or whether to understand whether the second to fourth defendant would even participate. The next point I would like to address is the fact that there would be wasted costs, and my learned friend has alluded to the fact that I had contradicted myself, that there would be wasted costs or there would not be wasted costs. And that to clarify this point, I made the point that there would be wasted costs only in the circumstances where D2 to D4 would appear. If they've been served, whether they would appear and how this would all have to be relitigated. But we do not have instructions. The counsel to the second to fourth defendant does not have instructions as to whether they will appear. We do not know whether this will be the case, and we do not know whether wasted costs will be incurred. If this case proceeds only against the first defendant, and there is a short adjournment of trial and the trial has to be relisted, there will not be any wasted costs. So, and if D2, D4 do not participate, if it just goes against the first defendant, there is not going to be wasted costs. It's merely a matter of staying these proceedings for a short period of time until we have a clarification on the position of D2 to D4. And if it proceeds only against the first defendant, briefing costs and all of these costs that have been incurred to date will not have been wasted. My learned friend has brought up that the expert reports will have to be redone, and this will lead to further wasted costs. Well, the expert reports and the quantification of the calculation is for the whole and entirety of the claimant's losses. This has been quantified on the basis that the case is proceeding against all defendants. If the case proceeds against all defendants, these will not need to be revised. In the skeleton argument, the first defendant has said that the wasted cost in redoing the expert reports is because the date upon which the quantification analysis has been made is the date on which the reports have been filed. And if this trial is set for a later date, the experts will have to redo their calculations. Well, My lord, the models have already been created and all of the inputs have been done. It's a matter of just updating the date on which the quantification analysis is made, and this is an automatic change, inputting some of the actual figures by the claimant during that interim period. It is not a Herculean task to update the expert reports in this way. The next point I would like to address is that this adjournment of trial will have disrupted the operations of the first defendant. That point is entirely unclear to me. What that means, how in a pending litigation matter would disrupt the operations of a bank. The bank is clearly operating, and this has no effect on the bank's operations or the employees of the first defendant. Finally, the point I would like to clarify is that my comment that it's not up to the court to decide how the claimant will proceed. And obviously the court has its case management powers to decide how this case will proceed or not. My point in making that was that if the second to fourth defendant are going to participate and the first defendant and the case against the first defendant proceeds, the claimant has the possibility of deciding whether to proceed only against the first defendant or against all defendants, taking into consideration the time and cost that will be incurred and or wasted costs that have already been incurred. It is the claimant's due process right to decide which claims will be brought against which defendants and in the manner in which it will be brought. And that is the limitation of what I said is within the claimant's due process rights. So I just wanted to clarify that as the final point. So we reiterate that the first defendant's case has changed, and even with this change, the case should proceed against all defendants because the facts and circumstances and the overall factual matrix relate to all defendants. Whether the claims affect certain defendants, the heads of claim affect certain defendants is one thing, but the factual matrix justifies a proceeding against all defendants. The prejudice to the first defendant is minimal. The wasted costs have been addressed, and any additional time that will be required, we can assess at that time. The Part 12 application needs to be heard, and that definitely justifies a vacation of the trial dates at the very least. And then adjournment can be decided once that jurisdictional application has been determined. And there is no further prejudice to the first defendant in terms of disrupting their operations or otherwise.
My lord, I'm sorry to interrupt, but there is just one factual clarification I wish to make from my learned friend's submissions, which is when he referred at paragraph 45 to the defence point, where it said the claimant calls revised bills of lading to be submitted by D4 to Mashrek, suggesting that that's somehow a factual point in dispute and that it might require involvement. That is picking up on a point of common ground, because at paragraph 24 of the particulars of claim, the claimant says that the claimant instructed the fourth defendant to negotiate the originals of the revised bills of lading through the claimant's other bankers, Mashrek Bank. So that's not a point in dispute. That's just repeating back something in the particulars of claim. So I just didn't want the court to be misled on that.
All right, thank you. Right, I'll give an extemporary ruling now. On Friday of last week, the claimant applied for the proceedings to be stayed until the parties had received confirmation from the central authority of the UAE that service had been effected on the second to fourth defendants. The application for a stay would therefore inevitably involve the adjournment of a trial which has been fixed for some time now, which is scheduled to start on the 18th of September and run for a week or so. It is self-evidently a late application made in the context of a significant history of discussion between the parties who have been served, namely the claimant and the first defendant, and the court, since January, February of this year about service of proceedings on the second to fourth defendants. The court has case management powers to decide whether or not it is appropriate to stay and grant an adjournment, and exercises those powers in a manner that is consonant with justice and convenience. It has regard to the effect on the parties, to potential prejudice involved to one or other party in either granting the stay or not granting it, and granting the adjournment or not granting it. Obviously, questions of costs and expenses arise in the event of such an adjournment, but there is in addition the question of allocation of court resources, having set aside a period of time for such a trial in circumstances where the case is essentially ready for trial as between the claimant and the first defendant, and arrangements have been made for witnesses to attend with all the inconvenience involved should that not then occur. Two things are clear to me in relation to the position of the second to fourth defendants, who have in the last few days applied to contest the jurisdiction of the court on the basis that any service affected on them is ineffective. There has been prior discussion with the court at previous CMCs about the validity of service by courier on the second to fourth defendants in China, where I said it was clear on the evidence then before me that service by courier would not be effective as a matter of Chinese law, and therefore not effective as a matter of the law of the DIFC. At the same time as having sought to effect service in that way, the claimant had sought to involve the authorities in the UAE and in China in service according to the provisions of the treaty between China and the UAE. It is now clear, and in fact has been clear for some time, that service has not been effected in accordance with the provisions of the treaty through the judicial authorities route. When the matter was previously discussed with the court, I made it clear that should there be effective service on the second to fourth defendants, inevitably there would be a delay of 6 months or more, because the second to fourth defendants would require that time at the very least to get their act together to participate in the proceedings. The second matter that is clear now and has been made clear by Mr. Chadwick, who appears for the second to fourth defendants, is that he has no instructions as to whether or not the second to fourth defendants will ever participate in a trial in this country, even if service has been validly effected or will be validly effected. In this context, it is worth pointing out that although the substance of Mr. Chadwick's application has yet to be determined as between the claimant and the second to fourth defendants in relation to validity of service, I have in fact already reached a decision on that in the context of the existing proceedings so far as service by courier is concerned. What is also clear simply as a matter of chronology is that the claim form expired some 8 months ago in December 2022. Friedman argues on the part of the first defendant that in the absence of any application for and grant of an extension of time for service, there is in fact now no valid claim form which can be served through the judicial authorities route upon the second to fourth defendants. If that is right, then if service is to be effected on the second to fourth defendants, then the claimants are going to have to start all over again and issue a fresh claim form unless they can persuade the court that a retroactive extension of the time for service should be granted. Such retroactive extension only arises in the context of RDC 7.23, and the court can only make such an order in the circumstances there set out. One of those circumstances is that the claimant has acted promptly in making the application for an extension of time. It appears to me to be impossible for the claimant to comply with that condition, having delayed for 8 months in making any such application, which has still not been made as of today's date. In the context, therefore, of considering whether or not a stay should be granted and an adjournment of the trial also directed, it appears that should the second to fourth defendants decide to participate in any trial following any valid service, the trial involving them would likely take place some 2.5 years from now. I say that for this reason. If the claimant has to start again in relation to issuing a new claim form and then seeking to serve out of the jurisdiction in China, current experience shows that service by the judicial authorities route is likely to take a period of a year or so. There is then a period of time during which the defendants in China would have to decide whether or not to file an acknowledgement of service, some 45 days, and whether or not there might be some contest about jurisdiction at that point regardless. Assuming no further delay at that point, acknowledgement of service, and then the usual run of defence, witness statements, experts, and the like, in a case which involves allegations of fraud against the second to fourth defendants, it seems to be inevitable that a further year to a year and a half would inevitably ensue. The application, therefore, for an adjournment of the trial fixed for next month against the first defendant, if it were to await that outcome, would result in a delay of some 2.5 years on the most likely basis that I can see for events transpiring. The question arises as to whether or not it is just that the claimant should be compelled, essentially, to proceed against the first defendant on its own when it wishes to proceed against the first, second, third, and fourth defendants together. The critical point, in my judgment, in this context, is that the issues are distinct as between the claimant and the first defendants on the one hand, and the claimant and the second to fourth defendants on the other. When previously this matter was discussed, I said that there was a significant overlapping of factual matters, because at that point it was being said by the first defendant that they suspected and certainly wished to investigate whether or not the claimant had been privy in some way to the fraudulent bills of lading, which it was common ground, as between claimant and first defendant, had been issued by the second to fourth defendants. It was on that basis that the first defendant was saying at previous CMCs that matters ought to be stayed to await the involvement of the second to fourth defendants. It was at that stage that the claimant was saying that the events should not be delayed to await service on the second to fourth defendants, it being their best judgment that the second to fourth defendants would be unlikely to participate in the trial in any event. I made it plain at that point that if no service was effected on the second to fourth defendants, some 6 months prior to September 2023, there would be no real possibility of the case going ahead against those defendants at that point, and therefore the matter should continue as currently scheduled and await developments. The claimants were told that they needed to keep the court updated on such matters, and in due course, on the 4th of May, the claimant informed the court that service on the second to fourth defendants had not been affected by the judicial route. Again, on the 17th of May, that was repeated, but it was not until the 15th of August that any suggestion of a stay of proceedings was first raised by the claimant, to which the first defendant then objected, and the claimant issued its application last Friday. The first defendant's position is that there should be no stay and no adjournment of trial, because so much water has passed under the bridge since the CMCs in January and February. Everybody is prepared for trial, and the allegations that are being made by the claimant against the first defendant, not simply in the pleadings, but also in witness statements, are serious allegations against professional people. In those circumstances, given the wholesale uncertainty about the involvement of the second to fourth defendants, who have currently objected to the jurisdiction and are not saying, even if jurisdiction by this court is finally determined in favour of the claimants, that they will necessarily participate. This claim says the first defendant should go ahead at the trial already fixed. It seems to me that if this matter was going to adjourn to await the position of the second to fourth defendants becoming clear, an application should have been made to this court some 6 months ago. And in the absence of such an application, whilst it cannot be said that the claimant has positively elected to go ahead against the first defendant and taking the risk that the second to fourth defendants would turn up in August of this year, as I had suggested might be the case in order to contest jurisdiction, that the claimant has brought on its own head the consequences of its course of action in persisting with movement towards trial, regardless of the absence of service by the judicial route on those defendants. when one examines the issues which are going to arise on the trial against the first defendants, attention has been drawn by Mr. Cooke for the claimant to two particular paragraphs in the defence of the first defendants. Those paragraphs being paragraphs 42 and bear with me a moment. I'm sorry, paragraph 45 and 52. What has been made plain by the first defendant through counsel is that for the purposes of the hearing in September, it will not be advancing any case that the claimant was party or privy to or involved in the fraudulent bills of lading. It is right to say that paragraphs 45 and 52 can be read in such a way as to suggest that the claimant was in some way involved in some elements of the fraud. Once, however, that point is excluded from consideration, what matters in the context of the claim against the first defendant is the first defendant's understanding of the position at the time, where it is common ground between it and the claimant that there were fraudulent bills of lading, and whether its understanding and its actions are then justified in the context of the facility agreement and the rights and obligations of the parties in relation to suspension and termination of the facility agreement. It seems to me that those points are self-contained and do not depend upon the factual position as it might ultimately turn out to be as between the claimant and the first to fourth defendants. I'm sorry, claimant and the second to fourth defendants. What requires to be examined by the court is the position as it was known to the first defendant, the bank, and in the context of its relationship to the claimant, and the common ground that exists between the claimant and the first defendant about the elements of fraud which were being perpetrated. Looking at the matter, therefore, in the round, it appears to me that it would be wrong and indeed unjust for there to be an adjournment of the hearing fixed for September, and there should not be a stay of the proceedings against the first defendant until such time as the second to fourth defendants are served, with all the uncertainty that is involved as to when such service might take place and whether or not the second to fourth defendants would in any event participate in any trial that might ensue thereafter. I should make it clear that although I've expressed views about the questions of validity of service on the second to fourth defendants and extensions of time for such service, those matters have not been fully argued before me as between claimant and second to fourth defendants, but nonetheless my conclusions appear to me to be ones that are going to be difficult for any party to challenge. Nonetheless, the application of the second to fourth defendants has not been determined as of now, and if the parties wish for the matter to go ahead and for those matters to be determined separately, they will have to do so in accordance with either the timetable prescribed by the rules of court or one which the court can lay down. The court has nonetheless to take views about such matters in order to determine whether or not the claimant's application for a stay and adjournment should be granted, and has of necessity, therefore, to take a view about those matters in coming to a conclusion. For those reasons, it appears to me that it would be wrong to grant the stay and the adjournment that the claimant seeks, and that the trial should go ahead in September as originally envisaged.
I'm grateful, my lord.
I was just going to check whether there was anything else I needed to say. No, I think that covers the ground, unless anybody can think of something I should have dealt with that I haven't.
I'm grateful, my lord. That leaves then the remaining matters. Firstly, the question of cost of that application, which I would suggest I deal with first, and then just to highlight the other issues. There's the question of the trial bundle, where at the time of writing my skeleton, it seemed like matters were agreed, but it hasn't been provided on time, and I do want to address my lord on that. We've then got the small dispute regarding the trial timetable, which I hope we can deal with in 2 minutes, and then the question of the extension for the reply expert evidence, which I imagine we can deal with in a few minutes on either side, if that. So is it convenient if I deal with costs now of the application?
Yes.
Yeah. So, put simply, we say cost should follow the event. We've obviously been successful. This is an application that has put us to substantial inconvenience, as can be seen from my skeleton argument, where the vast majority of that was spent dealing with that, including citation of authority, including going back over the Chinese authorities. It is and was a matter of substantial importance to both parties. We have been forced to fight it. It has been put very aggressively against us. They then doubled down based on the fact of the Part 12 application, which was likewise not a good basis. And so we do say that this is a matter that's had to be fought separately, and that costs should follow the event. We should get an order for our costs.
Yes, Mr. Kotick, what do you want to say about that?
The main basis for the judgment's determination today largely hinged on the fact that the first defendant had changed their position, that the claimant was not involved in the fraud and did not have prior knowledge of the fraud. This only came to the claimant's attention the day before this PTR hearing, and therefore, had the claimant had sufficient time to address the first defendant's change in position and reassess its stay application, there could have been another consideration on whether the claimant wanted to bring the stay application forward. And also, we had the jurisdictional application that was filed after the stay application was filed, which further provided complexity to the matter. The claimant raised the stay application as soon as it thought to be pertinent to adjourn trial, and the parties have exchanged very short witness statements. The first witness statement submitted by the first defendant was only a few pages, and the skeleton argument was prepared on the first defendant's own account. So they've incurred unnecessary costs if these are to be awarded against the claimant.
My lord, just sorry.
Don't need to hear from you, Mr. Friedman. Costs must inevitably follow the event. As I say, this application for a stay should have been brought months ago if it was going to be brought at all. So costs follow the event, and the first defendant is entitled to its reasonable cost. That could be the subject of assessment if not agreed.
I'm grateful, my lord.
I take Mr. Chadwick, your costs will certainly be costs in your application, so to speak. That seems to be the logical position to adopt.
I concur.
Yes. All right. Now, so the question then is directions for the future. The bundle of documents hasn't yet been finalised, as I understand it.
No. So if I may update on that and explain what our proposal is. A letter has been sent, in fact, during the course of the the hearing. It has been provided to the court, so I don't know if it's made its way to my lord yet.
No.
But essentially, where the latest on the trial bundle is that an index was sent, which we have now gone through, and there is some fairly substantial duplication, which we pointed out. Now, we're hopeful that that may be agreed, but essentially I'm going to be asking for two things. I do want to briefly just run through the history, so my lord has a sense of what we've had to put up with in trying to deal with this. Is that I'm going to suggest that there be a direction that that the claimant respond by a specified time, and that should, in my submission, that should probably be either later today or very first thing tomorrow morning, saying whether they accept, or if they do not accept with reasons, the relatively limited amendments we've made. But my second point is that we say that we should be given conduct of the trial bundle, and that will be better for everyone, because that will end up with Tamimi, which has taken an appropriate approach to this matter throughout, which is a well-resourced and experienced firm who know how to prepare a proper trial bundle, could provide the finalised version. But also they have already prepared effectively a final version, and so we can, within 24 hours of the index being finalised, provide that trial bundle. And so if I may just very briefly just run through what has happened, and this can be seen in the bundle for this hearing.
I don't think there's any point in you running through that unless there's objection to that course. Mr. Cooke, what do you say about that?
My lord, we have no objection to Mr. Fraser's proposal.
Yeah. Right. Well, in which case that's straightforward then. I'll give you 24 hours to reply in relation to the index, please, Mr. Matu.
I've just received an email from my team member. We have no objections to the.
Oh, right. Very good. Very good. All right. Well, that's straightforward.
There is a further issue, my lord, regarding reply expert reports. Claimant.
I realise that. Don't worry. We'll come to that in a moment. Do you? Oh well, if you want to introduce it, why don't you do that, Mr. Matu? It's you want the extension plans. You have to bear in mind that I haven't read the expert reports at all, so I'm not in any position to take a view as to what they do and don't include and what work's required in reply.
My lord, it doesn't require you to understand the substance of the expert reports. The extension is purely sought by the claimant on the basis that the principal associate of the claimant's expert, Mr. Puri, his mother is gravely unwell and had to leave work to attend to his mother. And Mr. Puri requested extension initially till 28th of August to finalize his expert report upon return of Mr. Sriman Jain to the offices. And then upon discussion with the first defendant, we had then requested to give us till 25th, if not till 28th. They did not respond to our proposal, and then we were compelled to make an application on Sunday night because the due date for the reply expert reports was 21st of August. So essentially, we just required a reasonable amount of extension because of this extraordinary situation facing our claimant's expert. So we request the court to grant us this extension. It doesn't prejudice the first defendant in any way, and it's a proper thing to do, given our expert is relying on Mr. Jain to help him with finalizing of the report, and also because he was principally assisted him on the joint memorandum. So he requires him to come back to the offices tomorrow and then finalize the report by 25th of August. We think the first defendant should have agreed to this by way of consent, that they unreasonably withheld their consent. And so much so that they even asked us to provide details of the illnesses of the experts' mother's illness, or so on and so forth, which we could not. We didn't feel it was the right and decent thing to do. So that's all we have to say on this. And I think this is a matter that should not have come here, but nonetheless we are here, and we respectfully request your lordship to grant us this extension.
Mr. Friedman, it's not going to make much difference, is it, in the context of this trial on the 18th?
Well, the background to this, my lord, is, and I do think this is an important background, is that we've been given a variety of explanations in relation.
Well, I
to
understand.
this.
I understand that,
Yeah.
But let's take the explanation I've been given at face value today.
So we do have two concerns about it. The first is a practical concern. The skeleton arguments in this matter are due on the 11th of September. So by my learned friend's proposal, that would, and there is an English bank holiday, of course, that would give me 9 working days prior to the skeleton, when the reports ought to have been provided yesterday, which would have given 14 working days. So I have time set aside this week to prepare, including on that important matter of quantum. And so in my submission, that is going to cause some difficulties on this side and reduces the available time, taking into account other commitments. So that is something that does matter to us. It is also something that is a concern, because we're concerned that this is going to be used as an excuse, in keeping with some of the manner in which this claim has been litigated by the claimant so far, to unduly expand what should be limited reply reports. And the third point related to that is that we do not think that there is a good reason for this degree of extension. That's why we proposed an extension of 48 hours. But put simply, the suggestion that somehow that Mr. Jain is the principal member is not borne out by the expert's own report, where he says that he was assisted in the preparation of this expert report by my team of qualified staff, including, then he names 4 people, and so presumably there are others, as it includes those 4. And those 4 people, Mr. Jain is not listed first even. It's not alphabetical, so there's nothing to suggest he was the principal person. They've known about this for some time, given that there is Mr. Puri himself, and indeed the other 3 named individuals, and having known about this issue and had the weekend as well to work on it, we do not think that an extension of time of 4 days, effectively a whole week, just a little over 2 weeks out from trial, is required. And we do say that when we're that close to trial, we ought to know as soon as possible. So we do say that it should be as soon as possible, and that rigour has to be applied as to the length. I accept that shortly before they issued the application, they brought it forward by 3 days, but nonetheless, I do say that Wednesday is the right day, and if not, Thursday rather than Friday.
My lord, if I may make a short point. If it's about resources, Mr. Holloway is co-counseling with Mr. Friedman, and they have a team of 7 other lawyers working on this matter. So the fact that somebody else can assist Mr. Friedman also to review the report next week. So this is a very short extension, 4-day extension, which our expert has said he requires, because Mr. Jain has principally assisted him in making the models and assessing the quantum. It's his direction to us. I'm no one to challenge his direction as an independent expert. So we say that it's not going to cause any prejudice whatsoever. There's the principal expert report has already been served. Joint memorandum has already been served, and reply expert report is going to be just focusing on the points where the experts disagree, which is on very limited issues, as we can see. And we say that any extension will not be of any prejudice and should not cause any issue for the first defendant. And there should have been no need for this application at all, given what our expert had said to us and what we had conveyed to first defendant.
Close of business Dubai time on the 25th, please.
We're very grateful, my lord. My lord,
No.
I just want to make one more point on costs of this unnecessary application. We think that it was unnecessary for us to make this application. We should have been agreed. This should have been agreed by consent, given it would be the reasonable thing to do. So we request the court to make a cost order in this application in favor of the claimant.
You needed the indulgence of the court, so I'm just going to say costs in the cause.
I'm grateful, my lord.
Right, now what else needs to be sorted out? There's a short timetabling point, but it doesn't seem to me that it's, we need concern ourselves on dealing with this. Provided counsel are being sensible about what they need to cross-examine on and what they don't need to cross-examine on, it seems to me we've got plenty of time for matters to be dealt with in the time available, and the opportunity for people to have a break before they have to produce their closing speeches on the Monday of the following week. Is there really a need for the parties to debate the exact amount of time to be accorded to cross-examination?
My lord,
I find this approach, which happens in arbitration all the time, that people require equality of time, just to be a nonsense. It all depends on what the witnesses have to say and what has to be challenged and what doesn't. And if counsel proceed professionally, I can't see why there should be a problem. Who is going to be actually acting as lead advocate in for each party? I mean, who'll be doing the cross-examining, in other words?
My lord, we have a counsel, Mr. Thomas Bryce from English KC will be leading the claimant.
Right, so he'll be doing the cross-examination.
Yes, along with us, because we have 5 witnesses and the expert to cross-examine. So we have 6 sets of people. Yeah, so he will be leading the claimant's team.
Yes.
On our side, my lord, Mr. Holloway and I will be splitting the cross-examination.
Yes. Well, and just tell me what the position is with regard to the evidence of Mr. Madwani and Mr. Debnath. They are former employees, is that right?
My lord, they are the claimant has not provided any evidence by compliance and AML officers during the time when the matters at hand took place. So we made witness summons towards these 2 employees to give evidence, and one of them has now left the first defendant's employment and is currently working in Citibank in India.
Right, so you've issued witness summons, and are you expecting both of these people to turn up, and have they provided any statements of any kind to either party?
Not so far, my lord. We have not heard any response from them. They're being served the witness summons.
Right.
The second individual is currently employed by the first defendant.
And in the DIFC?
That's correct, my lord.
Yes.
As far as we know.
Yes, I see. And what is the envisaged procedure, therefore? I mean, when people are subpoenaed, there are a number of different approaches that take place. You can have uncooperative witnesses who just turn up, and therefore the parties call them and examine and cross-examine them blind, in the way that witness evidence used to happen when I first began at the bar, long before witness statements and anything similar. That's one approach, but often when a person is subject to a witness summons, they give a statement on the basis they know they're going to have to turn up, and they therefore set out what their evidence is in the form of a witness statement, sometimes because they have engaged lawyers of their own to help them to produce it and so on and so forth. I mean, what's happening here? Is there any information about it or communication?
As far as we understand, my lord, we have not received any response from the two witnesses, additional witnesses. And we don't know if the DIFC...
Don't even know if they're going to come.
We have not heard anything on that so far. We have served them, and they have, as far as I understand in the procedure, 7 days to set aside the witness summons.
When did you serve them then?
Let me see. I have the. If you can give me indulgence, my lord.
Yeah.
On the 16th of August, my lord, 16th of August.
We're the 22nd today, right?
Yes.
I see. And Mr. Friedman, do you know about this? If one of them is a former employee and one is a current employee, presumably you know something about the latter at least.
Well, I can make inquiries, my lord, but I don't have instructions for any further information that I can provide at the moment.
Well, obviously this impacts on the timetable as to quite how they're going to be dealt with. I mean, I would have expected a current employee of yours who has been subpoenaed to be turning to the bank's lawyers to ask for advice as to what he should do. And the logical and sensible thing would be for him to produce a witness statement to the parties, which can then be the subject of cross-examination. Exactly how that works, because he's been subpoenaed, is another question. But broadly speaking, you would expect in those circumstances that the party calling him would have to call him, but would be enabled to ask additional questions on the basis of the witness statement. And then rather oddly, you would be entitled to cross-examine the witness. So far as the ex-employee is concerned, it all depends on your relationship with him as to whether he would turn to you for something, a similar approach. But it obviously makes sense, if it's possible, for those witnesses to produce witness statements setting out their involvement with this matter so far as they understand the issues to involve them.
Yes, and I fully take the point my lord is making. As I say, I'm not in a position to provide any more information now, but certainly we will take that on board, and we can investigate the position following the hearing.
Yes.
My lord, if I may, one point I want to make is it's assumed by the first defendant, also by their timetable that they sent us, that their current employee who has been, as you said, subpoenaed, will be giving evidence. So
yes,
I'm sure they must have considered as to what kind of evidence he'll be giving, whether he would be giving.
If I could just so we don't start a hair running on that, that was inserted into the timetable by my learned friend. So we're working on the basis that they say that they've summoned them and wish to call them.
Yes. Well, let's work on the basis that there's not going to be a challenge to the witness summons for the moment, and that being subpoenaed by the claimant, they are technically the claimant's witnesses, though they won't have any access to them beforehand, unless the individuals concerned are agreeable thereto, which in the circumstances seems unlikely. End result, it would make sense for there to be witness statements from them, which will at least perhaps shorten the need for cross-examination by one party or the other. Can that be explored, Mr. Friedman, with a view to production of witness statements within 7 days? I mean, I can't make an order to that effect because
Yes.
that's not how things work in the context of subpoena, but it obviously makes sense that you should attempt to do that.
Yes, we can certainly attempt to do that, my lord. I obviously can't say as to whether that is something we can do or within the timescale, give for the reasons my lord gives, but we'll certainly look into that based on what my lord has said.
All right. Now, in real terms, have people made any realistic assessment as to how long they really think they're going to need to cross-examine these witnesses for?
Well, please, go ahead.
No, sorry, I'll let my lord go first.
My lord, I have not yet finally prepared ourselves for the cross-examination, and we are the council team is still working on it, so we can't at this stage give a reasonable assessment in this regard. So maybe at the beginning of the trial, maybe we can give you some kind of assessment of that.
Well, what I'm going to suggest is that you seek to agree a timetable when you've had a chance to work out what you think is really needed, exchanging in correspondence between yourselves your estimates of the time you think you're going to need for cross-examination of each of the witnesses.
I think the parties can liaise with each other.
I should have thought leading counsel ought to be able to liaise with one another and come to some agreement. That's the normal thing.
Yes.
I don't think there's a shortage of time, and indeed, if all goes as speedily as I think it probably should, then I would have expected us to be able to get on to the experts and finish them probably by the end of Friday morning, which would give people Friday afternoon to think about what they're going to say on the Monday. That's my best guess, but you know, you're going to have to look at it and work it out for yourself. If there's a problem about it, then you can both write into the registry, and I can make a decision in writing in the week beforehand sometime. I know, you know, inevitably preparation of witness cross-examination is something that tends to occur shortly before trial. But when you look at the length of witness statements and see what the issues are, you must have some idea and can therefore have sensible exchanges. And if there's a problem, let me know in the week preceding trial, and I'll make any ruling that has to be given either then or on the first day of the trial.
Yes.
All right. So at the end of the day, we don't have any experts on either anti-money laundering or anything of that kind. No. They're just quantum experts.
That's right.
Yeah. And are they forensic accountants? Are we looking at, or what are they?
Yes, they are forensic accountants, my lord, and expert quantum experts as well.
Oh, it's actually there's only one on each side.
That's correct, my lord.
Yeah, okay, yeah, that's fine. All right. What else do I need to deal with? Anything else? Mr. Matthew, are there other matters that have to be raised?
Nothing further from our end, my lord.
From our side, my lord, it was just really to raise the points to confirm that my lord is happy with them, which is that firstly the parties have agreed that there be daily transcription, and obviously they will do the usual thing, and then also just to double check that the trial is as we have submitted respectfully is preferable is in person rather than remote.
Yes,
these have been already agreed, my lord.
Yes, I shall be flying out on Sunday night, so yeah, I shall be there in person. If there are conflicts of fact between the witnesses, as there appear to be, it's much better that I should see the witnesses eyeball to eyeball, and to take whatever view I need to take about it. So yes, it'll be an in-person trial.
Thank you very much.
All right.
That is everything on our side.
Very good. Now, so far as the only other outstanding thing is Mr. Chadwick's application. Do you need any directions at all about that, or do I just let things run when the parties have had a chance to reflect on things that I've said and work out what they want to do next?
From our point of view, I think we're content to go with the timetable that's in the rules, and then we can discuss trying to find an appropriate date that's available for the parties. I can see from the claimant's point of view, they may have clashes of preparing for trial at the same time as preparing for our Part 12 application. But we can discuss with them when they have availability for hearing our application.
Yes, well, there can hardly be said to be any mad rush about your application being heard, can there, at this stage?
I think it probably, subject to what the claimants want, it probably would end up being heard after the trial.
Yes. Yeah, all right. Yes, I don't think I can conveniently fit it in with the trial, or either before or afterwards. Well, let's see how it works out. But as matters currently stand, I'm certainly due to be flying back on the Saturday after the trial. All right. Thank you all very much. Such costs as haven't been dealt with so far, the costs of the PTR as such, will simply be costs in the case. Now, so far as drawing up an order is concerned, will the claimants have carriage the matter? Can you draw up the order and seek to agree it with Mr. Friedman and Mr. Chadwick, and then let me have a copy for approval?
Certainly, my lord.
Very good. All right. Thank you all very much indeed. And I look forward to seeing some of you at least in September. Thank you very much indeed.
Thank you, my lord.
Thank you.
If you'd like,
Thank you, madam.
if you wouldn't mind all signing out, then I can have a quick word with the associate. Thank you very much.